The idea when you have a sufficiency of evidence against an individual like Levi Bellfield that you don't prosecute for one of the most notorious cases of the past 20, 30 years, simply because he's already serving a whole life sentence is unthinkable. And no justice system should ever countenance that, and this one wouldn't. Bellfield ultimately is a coward, a liar, somebody who is very skilled at making black white and white black, a slippery character, as you would expect. What happened to the Dowlers and their view afterwards, the reputational loss to their family and the damage to their family was too high a price to pay. For justice, for Milly, was for me an abiding tragedy actually, and an indictment on the criminal justice system.
You are listening to Inside the Case, brought to you by the University of Law. 13-year-old Milly Dowler disappeared in broad daylight in March 2002. She was walking home from school in the streets of leafy Walton-on-Thames, Surrey, after leaving a cafe with friends. The shocking case sparked intense media coverage and would become one of the most high-profile in modern British criminal history. She had disappeared in the blink of an eye, as prosecuting counsel put it, a scenario that was every parent's nightmare. A body was found 6 months later in woodland 25 miles away. The police had few leads and the case went unsolved for several years. But 6 years later, in 2008, Levi Bellfield, a nightclub bouncer and wheel clamper, was convicted of the murders of two other young women, Marcia McDonnell in 2003 and Amélie de Lagrange in 2004, and the attempted murder of a third. Those convictions were a turning point. Bellfield was strongly suspected of the abduction and murder also of Milly Dowler, but there was no forensic evidence to link him to the crime. After further painstaking investigations, he was finally charged in 2010 with Milly's kidnap and murder, 8 years after her death. He was tried and convicted in 2011 and given a second whole life sentence. The case had a huge political impact, leading the government to set up an inquiry into press standards and ethics, and the closure of the News of the World newspaper after the discovery that its journalists had hacked Milly's phone. In today's episode, I'm joined by the barrister who led the prosecution in the case, Brian Altman KC, one of the country's best-known and most experienced criminal lawyers. Altman served as Treasury Counsel at the Old Bailey for 16 years until 2013, including a period as first senior Treasury Counsel, prosecuting some of the worst and most horrific crimes from the 1982 Hyde Park bombing to Russell Bishop in the 2018 Babes in the Wood murder case. Altman is head of chambers at 2BR, where his practice has since shifted to public inquiries. He was appointed lead counsel by the Independent Inquiry into Child Sexual Abuse in 2016 and was lead counsel for the Post Office in the 42 sub-postmasters' appeals in 2021. He currently acts for the MOD in the Afghanistan inquiry and is advising Boris Johnson in the COVID inquiry. I began by asking him if he remembered first hearing the name Levi Bellfield.
Well, I think the first time I heard the name Levi Bellfield was, like many people in this country, after he was arrested in November 2004 for the murders of Amélie de Lagrange in 2004 on Twickenham Green, Marcia McDonnell, who was killed in 2003 in Hampton, and the attempted murder of Kate Sheedy, also in 2004, in Isleworth. And I remember at the time that there was a big public kerfuffle.
Lots of publicity about those cases.
Yeah, although, of course, because it was these were live proceedings, very little could be said. But I do remember the name. When you asked me to do this podcast, I had to look back at my records, some of which I still have. And I discovered that the first written opinion I had given to the Crown Prosecution Service, together with then junior Treasury Counsel, Mark Hayward, who ended up like me as first senior Treasury Counsel years later, was dated the 17th of February 2006, and we were asked, in essence, to advise the CPS and the police whether there was, in simple terms, a sufficiency of evidence for Bellfield to be charged, in particular with those three cases. There were others. I, together with Mark, gave that advice, and to give you an idea of the volume and complexity of the case, that written advice ran to 163 pages and 469 paragraphs. And that advice was delivered to the CPS in due course. The CPS sat down with us and the police. I'm sure we had many conferences to follow. And in due course, Bellfield was charged with those two murders and with the attempted murder of Kate Sheedy. And he was charged between March and May 2006.
Yeah. Why was there so much material in that case?
There were three major offences, but there were others that the police were investigating. The case was highly circumstantial. Bellfield was a very sophisticated, savvy criminal, and he understood surveillance and he operated anti-surveillance techniques and tradecraft, in effect. And the police had to trawl through thousands of hours of CCTV evidence, in those days analog, not digital, from moving vehicles like buses, shop fronts, council cameras, together with hundreds of phone records from various sources, in order to track the movements of vehicles in those three cases, different vehicles that were associated with the offences. Okay. As well as Bellfield's relationships with various people. It was a massive, massive undertaking.
So that case came to trial, and you were in it, I believe.
Oh yeah, so the CPS agreed with our advice that there was a sufficiency of evidence, and it was clearly in the public interest to charge Bellfield. He was charged with those three offences and a couple of others, actually, in respect of which the jury ultimately couldn't agree. But he was charged with those three offences. The case came to trial in October 2007. It lasted till February 2008. So if my memory serves me, it lasted something like 5 months.
Gosh.
Yeah. Bellfield was convicted of the three principal offences, so the murders of Amelie and of Marcia, and the attempted murder of Kate. And in respect of two other offences, one was an abduction of a young girl in West London in 2001, and the other was an attempted murder of another woman in 2003. The jury couldn't make up their minds. Right. And therefore the jury was discharged in relation to those two, and for various reasons there were no retrials.
So how did we then get from that point to the case of Milly Dowler?
Well, you've got to remember that the cases I've been talking about were investigated by the Metropolitan Police in London under the fantastic leadership of Colin Sutton, who was the senior investigating officer. If my memory is right about this, it was during the course of their inquiries that they stumbled upon the fact that Bellfield's then partner, Emma Mills, had a flat at 24 Collingwood Place in Warton-on-Thames, which was literally over the road from Warton-upon-Thames station, from which Milly effectively disappeared on the 21st of March 2002.
So that was the first kind of connection with anything to do with her case.
If my memory is right about that, that was the first link that they met during the course of their inquiries on the other cases, stumbled upon that bit of evidence, and that led to other inquiries.
She had, of course, gone missing and then been found murdered. Yeah. Some years before, 5 years before at this point, I think.
Yeah.
So the case hadn't gone cold. They were still keeping an open eye.
Well, it was Surrey Police, in fact. This was a Surrey Police investigation, the Milly Dowler case. And although I think there were certain people who would quite like to have joined the cases together, Colin Sutton, I remember having a conference once when that notion was discussed. I wasn't in favour of it. I wasn't in favour of it because at the time I felt that more work needed to be done.
Do you mean join her case
to the others?
To the others.
Yeah, I felt more work needed to be done in order to make it trial ready, and it wasn't ready at that time. Secondly, and in any event, I was concerned that such was the notoriety of the Milly Dowler case that it would just completely swamp the other cases which we had already advised were sufficient for trial, and the CPS had agreed and were trial ready. So for those reasons, in essence, just purely in general terms, it was not joined. As I say, I was against it. In fact, Colin Sutton, in his book Manhunt, I think, devotes a few pages to that particular debate. And so it went off. So we prosecuted successfully the two murders from 2003, 2004, and the attempted murder of Kate from 2004. And as I recall it thereafter, I did quite a bit of advisory work on the Milly Dowler case. And the following year, the CPS, and I think it was one of the senior lawyers within Surrey with whom I'd had other dealings and had some dealings on the Milly Dowler case, he chose to make the charging decision himself. And he did, and he advised that there was, again, a sufficiency of evidence or a realistic prospect of conviction, certainly in the public interest, to charge Bellfield at that time.
What made the case of Milly Dowler difficult was the lack of any forensic evidence. It turned on circumstantial evidence only, and a crucial element of that was whether Milly was caught on a particular CCTV camera close to Levi Bellfield's flat. If she was not on that camera, he had by that time abducted her. What was your feeling about it? Did you think that he was likely to be the suspect in her case as well as the others?
Yeah.
You were pretty certain about that.
Certainty is a luxury, and perhaps it's not the same thing as a jury being sure, but I was happy that there was a realistic prospect of conviction of him on the available evidence. It was like the other case, it was a highly circumstantial case, by which I mean there was no direct evidence.
No. So when you say it was highly circumstantial, one thing I'd like to ask you, this case was extremely difficult in many ways to prosecute, wasn't it? And that was probably the chief reason, would you say, that there wasn't any direct forensic evidence. Can you elaborate on that a bit?
A circumstantial case or an indirect evidence case is one which is built upon various bits of provable evidence from different sources, which you hope combine to make a compelling case against the defendants. And sometimes circumstantial cases are far more compelling than direct evidence ones. But the Milly Dowler was highly circumstantial, as I say, just like the trial before it, where we had to stitch together bits of evidence from all sorts of different sources: CCTV, phone records, elimination of vehicles, thousands of them in the first trial. And this was very similar. But the Milly Dowler case rested critically, but not exclusively, on one fact, and that was that Milly had decided when she came home from school that day to get off at a train station one stop earlier than she ordinarily would, because she wanted to have a bag of chips with some friends. And instead of getting back on a train to go the next stop closer to her home, she decided to leave Walton-on-Thames station and walk up Station Road in the direction of home. I always felt that what she obviously did was she crossed the road to be on the side of the carriageway in the direction of home, hoping that her mother, who was a teacher at her school, would be driving up behind her to give her a lift on the way home. And there was support for that from one witness, a schoolgirl who knew her, who was on a bus which passed in that direction, and she saw her very close, I think, to a bus stop, which was itself very close to Collingwood Place. But one of the keys to all of this was what was known then, doesn't exist anymore, as the Bird's Eye building, which was further up the High Street, or the Station Road, forgive me, in Walton-on-Thames. And there was a CCTV camera, an old-style analog time-lapse camera that rotated every few seconds. And it was poor quality. And originally, Surrey Police sent it off to the FBI in the States to see if they can improve it.
Because we didn't have the facility to
obviously not.
get it to a good enough.
No, obviously not. Anyway, long story short, the key, one critical issue was if Milly had passed that camera, or put it another way, if we could not prove that she hadn't, then the case was sunk. Because if she had passed that camera, or the prosecution couldn't prove that she had not, then our case, which was that Bellfield was at Collingwood Place at that time and effectively plucked her off the street,
right,
and then killed her.
Right, I see.
Couldn't succeed.
So it was critical that
it was critical that we were able to prove that she did not get beyond that.
Get to that point.
Exactly. As for Collingwood Place, Emma Mills and Bellfield and their kids were not in fact living there at the time. It was still Emma's flat, but they were babysitting for some friends of, or house sitting for some friends of Emma's.
So he was alone in the flat?
Well,
or we think?
Well, we don't, I can't remember now if he was living there. He was certainly there. And the case was that he was certainly there because within about 20 odd minutes of Milly going missing, in other words, disappearing off the street, a red Daewoo Nexia, which the family had, was seen by another CCTV camera driving out of an access road from these flats into Station Road and driving off. And our case was that he had clearly either abducted or killed her in that period of time.
Do you think it was a very strange case because it was in broad daylight?
Yeah.
And people around, obviously. Yeah. I mean, do you think he lured her into the car? How do we think?
I can't remember exactly if we, one has to be careful about speculation. But it either happened in one of two ways. Either he saw her and grabbed her and got lucky, which Bellfield seemed always to be, or somehow he lured her because the flats had an entrance, but there were high hedges on either side of this entrance. So if he managed to lure her, nobody would see behind those hedges that sat on on the pavement on Station Road. No one would see him luring her away. And then, there was lots of circumstantial evidence surrounding all of that, not just Milly's disappearance in that place at that time. There was the car that suddenly drove away, which only he was driving at the time. The car disappeared, which was a favourite of Bellfield's. Cars that he used for crime, serious crime, were never found. They were scrapped or whatever, but they were never found. And where she was found, where her body was found 6 months later in Yateley Woods.
Which was some 25 miles away.
Yeah, but it was a place that he had frequented with a former partner for horse trials and that sort of thing.
So putting together all these pieces, you built up a strong case.
Yeah, in the end, I think it was. I mean, there was quite a bit more in terms of, the circumstantial evidence we were able to put together. For example, getting rid of bedding in the flat and that sort of thing. Getting up in the middle of the night to go telling Emma while they were house sitting in West Drayton that he had to go somewhere or go to the flat. I don't remember exactly what, but there were a series of circumstantial facts which we were able to string together to put together a highly cogent and coherent case against him.
How difficult a case was it? I mean, you're highly experienced. You've done many similar cases. Well, not exactly the same, obviously, but you've done many murders. How difficult was this one? Was it particularly difficult because of the way, what you just described, not having the forensic evidence, or was it particularly emotionally difficult?
All cases of a circumstantial nature are difficult, but this one came with an extra layer of difficulty and responsibility because Milly had disappeared in 2002. Here we were prosecuting it in 2011. Several years later, it had been in the public consciousness for many years.
Yes, I mean, that delay alone must have made it quite hard.
Yeah.
And the expectation, the weight of expectation,
Yeah.
you obviously didn't want to let the family down.
No, it's a huge responsibility that you have to shoulder. And we also had, of course, one of the most important bits of circumstantial evidence, if you like, which in years gone past you wouldn't have had. We were able to prove the other murders against him as evidence of bad character.
Oh, yes.
And therefore, and put together similar facts, use of vehicles.
Yes,
and
that used not to be allowed, did it?
No,
but by then it was.
By then it was perfectly ordinary. That didn't mean to say that the prosecution had carte blanche to put evidence of past convictions or post convictions, in this case, before juries, and it had to be properly argued and considered by the judge, but it was, and we succeeded.
The trial at the Old Bailey before Mr. Justice Wilkie commanded huge media publicity over its 6 weeks. A particularly controversial aspect was the defence cross-examination of Milly's father, Bob Dowler.
For us, the trial has been a truly awful experience. We have felt that our family, who have already suffered so much, has been on trial as much as Mr. Bellfield.
The Dowlers were left visibly shocked and shaken, and the press was highly critical of the defence approach. Do you remember the atmosphere in the trial? I expect it was extremely well attended. It will have had press benches packed to overflowing, public benches. Yeah. Do you remember it?
Oh, I do.
And how? Yeah. What do you remember from it?
I mean, I do remember that, you know, as I often say, the world's press were there on a daily basis. What I particularly remember, of course, is the Dowlers and the evidence they had to give. Mr. Dowler, who gave evidence about the disappearance of Milly and was cross-examined about his particular lifestyle. And Mrs. Dowler, who gave evidence, if my memory is correct, after him, was also asked about those aspects of her husband's lifestyle. The whole point being, or the defence being, that it was Mr. Dowler's lifestyle that, in effect, had led Milly not to want to be at home with him, home alone, on the 21st of March. Therefore, she ran away. Yes. Or she hung back or diverted and fell into the arms of someone who wasn't Levi Bellfield. That was the whole thesis.
So in some way, they were suggesting, the defence, that he was responsible, which must have been a very hard line of questioning for them to take. And I think they did describe it as cruel, and they had subsequently described their cross-examination as an absolute ordeal.
Yeah.
Did you think it was a justified line of questioning?
You know, the problem is, when you're prosecuting a case, you have to look at what the defence is. Is it a legitimate defence? And a legitimate defence would be that it wasn't the defendant who abducted and killed Milly, but it was someone else. In technical defence terms, if those were Bellfield's instructions, it was legitimate for my opponent to put to the Dowlers his, as it were, case theory, so that they could deal with it. To the outside world, I understand.
Do you think that came from him then?
I would hope so, because if it didn't, then counsel had no right floating pretty awful theories. Mm-hmm. But I assume it came from Bellfield, but of course I have no particular insight because I'm not privy to discussions between him and his counsel, which are privileged. I mean, it worked in the sense that the judge was forewarned by counsel for the defence that this is what he was going to do. So he understood what was going to happen, and he didn't prevent it, and he was right to, because in the end, you know, if the prosecutor seeks to prevent admissible evidence or an admissible line of questioning going before a jury, then all you're doing is providing a ground of appeal later. So yes. I don't want to say that that was our thinking at the time, but it is something that you have to have in mind. We couldn't have prevented this. No. It was, I think, however ugly and nasty, it was a legitimate line for Bellfield to take.
But you're saying that they felt it was actually perhaps not worth it.
Well, they obviously felt it was gratuitous, and they clearly felt that the price they had to pay for
getting justice,
all of the outing of their, you know, internal family life, invasion of privacy, and all of that was not worth it. I can tell you that my then junior and I were sufficiently worried.
Who was your junior at that time?
It was Duncan Atkinson, who is now himself King's Counsel and was also Treasury Counsel. We were sufficiently concerned, you know, in the knowledge that it would be, you know, a feast for the media, all of this, that we sought to persuade the judge not to allow publication of the cross-examination. And we knew it was a tall order.
You made an application.
But we made an application to prevent publication, but he ruled against us. And I'm not critical of him for doing so, because in the end, I think
would have been quite unusual.
It would have been exceptional, if not unique, and probably wrong. And then the press would all run off to the High Court to get that changed. But we felt we had to do something, because I just knew, we knew what the effect of it would be.
Yes. I suppose some people, given his conviction and the fact that he was then serving a whole life sentence for the other murders, some people might have said, why do it? Why put the Dowlers through it? Was it worth it? Why would you go ahead and prosecute a second time?
For the simple reason, first of all, when the case started, I don't think anybody really understood what was going to be put to the Dowlers and the effect it would have on them. But even beyond that, that's a private and understandable private interest, but there's a public interest. And the idea, when you have a sufficiency of evidence against an individual like Levi Bellfield, that you don't prosecute him for one of the most notorious cases of the past 20, 30 years, simply because he's already serving a whole life sentence, is unthinkable. And no justice system should ever countenance that, and this one wouldn't. But it just set the tone for what came after, because, you know, my particular memory of that being put to Mrs. Dowler is after she'd finished her evidence. She left court, and all I could hear was screaming, because she had clearly collapsed, as I discovered outside, physically collapsed to the floor, and screaming, which was her, or Gemma, her daughter, who was in court for that period. And that just you know, just led to the highly charged tone of the case after. I mean, Mr. and Mrs. Dowler had engaged with the process, as had Gemma. I'd had meetings with them, but I don't think anything prepared them for that.
No.
And the truth be told, I'm not sure that I even knew that that was the line the defence were going to take until really late into the trial. And I can't remember now if, when we knew it, we were able to tell them. I think we did, but I can't quite remember now. But understandably, after that, they disengaged from the process.
Did they not? They didn't come anymore? Or
as I remember it now, they didn't come for some time.
Right.
But towards the end, I think they came back to see the final outcome.
Well, it must have been truly horrendous for them. And did it affect the way you felt about it all? I mean, did you find that quite disturbing? Or you case hardened, as they say?
Yeah, I mean, inevitably you become desensitized. I mean, you've done it all, you've seen it all. But these people, Dowlers in this case, who come to a trial as victims, who engage with a process in which they feel disenfranchised because they have no direct say, and even, as we do these days, meeting victims and speaking to them, you have to run the case in the way that you feel is right. You can't be a mouthpiece for people.
No.
We don't have, for example, a French system where victims have representation.
No.
At least not yet.
No.
But
and do you think it's a better system that we have in that regard?
Well, if you take the view that a case has to be prosecuted in a certain way based on the evidence, admissible evidence, legal arguments should be taken which are appropriate and justified, then it's hard to see how somebody else with an emotional link to the case should necessarily have any particular say other than protecting their interests and rights as victims. Mm-hmm. That much, of course, I endorse, but
yes.
And any engagement other than that is, under our present system, our adversarial system, I find hard to understand how that might work.
Right. So the trial ran over, I think it was about 6 weeks.
Yeah.
And was there a particular point in it when you felt fairly confident, in as much as you would feel confident, that you were going to nail it?
No. You know me, Frances, I'm never confident. I'm the world's worst pessimist. You're never confident until, as a prosecutor, you hear the word guilty. Because you just don't know. You can't read juries. We all think we can, but in truth, you never know what a jury will do until they've uttered the words guilty or not guilty.
Yes.
But we all had pet theories. My pet theory was, if close to the delivery of a verdict or verdicts, they would come dressed in dark clothing, then that was curtains for the defendant.
Is that just your own theory?
That was my theory. It often worked. If they came in, they'd all been very colourful in the days before, in the middle of summer, as this case was, but suddenly they all turned up in suits and ties and dark clothing.
How do you notice that from your previous
I've noticed that. I've noticed that in the past. And then on the actual day of delivery, when they filed into court to deliver the verdict, as long as none of them looked at the dock, then I thought that confirmed my theory.
Now, Levi Bellfield himself, he didn't go into the witness box,
no.
Did he?
No.
What did you make of that?
Well, Bellfield ultimately is a coward. He'd had 3 or more days of me in the first trial, and I don't think he found that particularly pleasant experience. I suspect his counsel told him that any advances, and they would have been minute, but any advances they'd made in the course of the prosecution case were not going to be improved by his going into the witness box. And as I say, I suspect he realised that I'd destroy him.
From your earlier cross-examination of him in the other cases, what did you make of him as a person?
A liar. Somebody who is very skilled at making black white and white black, very quick at lying about anything that was put to him, and a slippery character, as you would expect. Somebody who'd lived his life that way.
Mm-hmm. But of course, he must have weighed the chances, and as you say, decided it wasn't it was nothing for him to gain by going.
No, there wasn't.
Being cross-examined by you.
Well, he's learned his lesson first time. I suspect he didn't fancy his chances second time.
Was the verdict ever in doubt?
Well, as I said, verdicts are always in doubt until they're uttered. You asked me earlier if I was confident. I was reasonably confident we'd done as much as we could. But it was, as I say, a highly circumstantial case, and you just don't know if a jury is going to accept your arguments and submissions about how all of these circumstantial facts fit together and why they point to him to the exclusion of anybody else in the world.
Given the high-profile nature of this case and the extraordinary media interest in it, Did that make your job all the harder?
Well, it does, in a sense that, you know, a lot of the cases I did over the years, like my colleagues did over the years at the Old Bailey as Treasury Counsel, were high profile. Some were just more high profile than others. And they attract an awful lot of media interest, and you realise that your every word is going to be published.
Do you get nervous?
Oh, yeah. Yeah, I always, you know, people think you don't, but it's all in the preparation. Yeah, obviously you get butterflies, and I always thought if I could get past the first 15, 20 minutes of opening a case to a jury, then I was doing fine and I'd get into my stride. But the first 20 minutes, getting the words out without sounding nervous, was a feat in itself. And, you know, also for the bigger cases, we all did it. You know, you wanted to give the media a bit of a strap line, a bit of you know, a hook to hang their reporting on. And in Milly's, it was gone in the blink of an eye. And that's exactly what happened to her.
The case had a huge political impact, leading to an inquiry into press ethics and standards under a senior judge, Sir Brian Levison. It emerged soon after the trial that journalists from the News of the World had hacked Milly's phone. They were further accused of causing her messages to be deleted, raising hopes that she was alive. That false allegation by The Guardian had to be retracted. The messages had dropped off automatically. But the public outcry over the hacking was such that the 168-year-old newspaper was forced to close. The case had a huge political and legal impact, as we know, because soon after the end of the trial came the disclosure that Milly's phone had been hacked, and that in turn led ultimately to the closure of the News of the World.
Yeah.
You weren't involved in any of that, but what did you make of it all?
I knew something during the course of the trial. I was tipped off that there were issues around her phone. And you bear in mind, this was 2002, so they're not like the kind of phones we have today, smartphones.
No.
And in those days, you might remember that if you had a voicemail inbox, it would only contain a few voicemails. And if somebody else left a voicemail, then the oldest ones would drop off. And I think, although I'm not sure it was ever proved, that might have happened on Milly's phone, which if it did was wicked, because it would have given the parents false hope if they were able to phone and leave a voice message when they hadn't been able to before. To Milly's phone, it would have given them hope that she was still alive somewhere and accessing her messages. But as I say, I don't think that was ever proved. I don't think the Levison inquiry ever proved that. But what they did find was that the News of the World had managed successfully to hack into her phone and listen to messages, and had misunderstood there was one message which had been left, which was left for the wrong phone. And they had taken that as being fact, and it had led them to publish false leads. And, you know, I mean, if Levison has any effect, I hope that, although it's less likely to happen today, at least with the smartphones we all own and use, but even so, you know, as a general principle, it's just off the pitch.
Yes, because following the disclosure about the hacking, as you say, an inquiry was set up under Sir Brian Levison into press ethics and standards. Do you think that has changed the climate at all in your dealings with the press, or your observations of how the media operate?
I haven't seen anything one way or the other. I suspect the only way I can answer that is like you. I haven't seen any adverse reporting of this sort of thing happening since.
So there's that on the one hand was the bigger political picture, but coming back to the actual case itself, what's your own kind of personal lasting memory of it and your feeling about it? It was such a big and emotional case.
Personal pride, professional pride. Bellfield, I think, remains the only person in this country to have received 2 whole life sentences in 2 different trials.
So he got one for the original trials that you did,
and for this,
and then for this.
But there's also the fact that in the Milly Dowler case, we did prosecute another case of, I think, an attempted abduction. It was of another young lady, as she was at the time, or girl, which was evidentially sound, but the judge took the verdicts on Milly's case, and the press had a free-for-all overnight, so much so publishing stuff that was not evidence in the course of the trial, and the effect of that was the judge was persuaded the next day to discharge the jury from further considering the case of the other girl. They had not yet come to their verdict. The defence counsel said it's unfair to allow this jury to carry on deliberating in relation to this other charge because of all of these stuff which has been in the media overnight, and the judge agreed and therefore discharged the jury. So she never got justice.
Right.
That girl, for what had happened to her,
Yes.
and I actually have absolutely no doubt it was Bellfield. So that's another abiding memory, but you know, the overwhelming one has to be Mr. and Mrs. Dowler and Gemma, and their takeaway from this case is it was just not worth it, which is a great shame. What happened to the Dowlers and their view afterwards that the reputational loss to their family and the damage to their family was too high a price to pay for justice for Milly was, for me, an abiding tragedy, actually, and an indictment on the criminal justice system.
Levi Bellfield is currently serving 2 whole life sentences, meaning that he is likely never to be released. Brian Altman KC is specialising in work on public inquiries and is currently advising Boris Johnson in the COVID inquiry. This episode is dedicated to the memory of Milly Dowler, Marcia McDonnell and Amélie de Lagrange. This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.